versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Buckle up, guys. Today we are going to step into a courtroom moment that starts out looking routine but quickly tilts into chaos. What begins as a standard hearing takes a sharp turn when a defendant, fueled by blind confidence, decides she doesn't need the attorney who's already secured a deal for her. In just seconds, you'll see the setup for a legal disaster unfolding live as she fires her lawyer. This intro sets the tone for an unraveling that becomes more unbelievable with every minute.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason.
Oh, the Austin card.
All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
No.
All right, guys, now we enter the point where confidence meets catastrophe. The defendant boldly declares she can handle her own probation violation hearing, tossing aside experienced counsel with nothing more than misplaced faith in herself. The judge patiently warns her that self-representation means following real legal rules, not fantasy ones. She signs away her rights without hesitation and demands a contested hearing. This moment marks the beginning of a self-inflicted legal crash no attorney could have saved her from.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample from Miss Clark?
It was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes. And I did. I received that. And apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
Guys, now watch how quickly her strategy begins to crumble. When the judge invites opening statements, the prosecution calmly declines, knowing their evidence speaks for itself. But when it's her turn, she freezes, offering nothing but an awkward refusal that reveals just how unprepared she is. This is the moment you can practically feel the courtroom's air shift as her earlier confidence evaporates. And with that silence, the stage is set for the prosecution to take full control.
All right. Do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right. Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
Buckle up, guys, because here the prosecution unleashes the full weight of the case. Her probation officer steps up and methodically lays out every violation in stark detail. A positive meth test, assigned admission, failure to report, new charges, and disappearing altogether. Each answer lands like a hammer, leaving no room for denial or escape. By the time he finishes, the damage is complete. This is the point where the courtroom realizes she's built her entire defense on nothing but thin air.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
All right, guys, here comes the turning point where her defense hits rock bottom. After hearing damning testimony, she has the chance to question the witness or introduce evidence. Instead, she offers nothing but silence followed by a confused claim that the court lacks jurisdiction. It's clear she has no legal argument, no proof, and no understanding of the process she insisted on handling alone. This is where her sovereign citizen script begins to collapse under the weight of reality.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Buckle up, guys, because this is where things shift from misguided to unbelievable. The prosecutor delivers a solid, fact-driven closing that neatly ties every violation together. Then she steps up with a speech pulled straight from an internet fantasy, claims of fictitious plaintiffs, missing injured parties, and bizarre references to IRS compliance. None of it connects to her case, and all of it reveals how deeply she misunderstands her own situation. This is the moment her fate becomes sealed.
Alright guys, that's the end of the video. As it turns out, having a public defender is way more effective at ensuring your freedom than representing yourself and doing nothing at all. So if you liked the video, leave a like. If you disliked it, leave a dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content.
Alright, guys, this final part brings everything to its inevitable conclusion. The judge calmly reviews every violation, from meth use to skipped reporting to ignored treatment orders. With each finding, her options shrink until there's nothing left but revocation. When he orders her into custody, she erupts with the now infamous claim of being owed $1,200 per minute in jail. The outburst changes nothing. The hearing ends exactly as expected, with consequences she brought on herself, one decision at a time.